Good morning, dear students. This is our last video or last chapter for our second periodic test, and in this video we are going to discuss about lesson number 5 of your civics about judiciary. Before starting the chapter, let me tell you, this chapter I have divided into two parts, part 1 and part 2. In part 1 we shall discuss half of the chapter, and in the next video we shall be dealing with the rest of the chapter. Now, before going to the chapter, you should know what is the meaning of judiciary. We can say in very simple sense, judiciary means the system of courts. The system of courts in our country is known as the judiciary. As already discussed earlier in the earlier chapters, that the government has three organs: the executive, the legislature and the judiciary. About executive and legislature we already discussed in the earlier chapters. In this chapter we shall be discussing about mainly judiciary. The first thing that we are going to study is here about role of the judiciary. What are the functions of the judiciary? The system of court settles down the different types of disputes. Whenever we think about court, a clear image comes into our mind that the court, they gives justice to the people. There may be different types of disputes, different types of quarrels may be there between citizens, between the state government and between citizen, and even between the state government with the central government. So all these type of disputes or problems are generally settled down by the system of court or by the judiciary. The work that the judiciary does can be divided into the following. Here we are going to discuss about the role of the judiciary. 3 points are there. The first point is dispute resolution. The second point is judicial review, and the third point is, here you can see, upholding the law and enforcing fundamental rights. One by one we shall try to understand. The first function of the judiciary is dispute resolution. What is the meaning of dispute resolution? The judicial system provides a mechanism for resolving disputes between citizens and the government, between two state governments, and between the center and the state governments. As I already told you, the basic function of the judiciary is to solve the disputes or the problems, and these disputes, it can be of different types. It may be between citizens about different matters like matters of land, marriage, property. Because of all these things, disputes may be there between citizens. There may be disputes between citizens and the government. Suppose government has framed one law, it is against the right of the citizens or a particular community. That problem also will be settled down by the judiciary. Even there may be problem between the two state governments. For example, the states, they share the common boundaries. Like our Arunachal Pradesh and Assam, they share the same boundary. So regarding the land matter, regarding this boundary matter, there may be some problems. So this also comes under the court. And even sometimes there will be problem between the central government and the state governments. This problem also will be settled down by the system of courts or by the judiciary. That's about the first function of the judiciary, dispute resolution. Well, now we are going to discuss about the second function of the judiciary, that is judicial review. What is the meaning of judicial review? As the final interpreter of the Constitution, the judiciary has the power to strike down particular laws passed by the Parliament if it believes that these are a violation of the basic structure of the Constitution. Remember one thing, we already got in our earlier chapters that legislature, they frame the laws, that is Parliament. The member of the Parliament, they frame the different types of laws, or they even change the existing laws. Already we got in our previous chapter. Now, the final interpreter of the Constitution is the judiciary. That means the judiciary can interpret, the judiciary can interfere into the matter of the Constitution if it feels that any law passed by the Parliament is against the structure of the Constitution or it is against the right of the people. At that time, the judiciary, it has full right to strike down such law passed by the Parliament. So we can say, through the function of judicial review, the judiciary has the power to ban a particular law which has been passed by the Parliament, in case if the judiciary feels that the law is against the constitution or against the right of the people. That's about the second point. Now, the third point that we are going to study here is about upholding the law and enforcing fundamental rights. Upholding the law means, the laws are framed by the parliament, and the constitution has given us fundamental rights. In the first chapter of our civics, we discussed about the fundamental rights, so I am not going there now. Let's see what the judiciary does generally under this. Every citizen of India can approach the Supreme Court or the High Court if they believe that their fundamental rights have been violated. We can say any person, if we feel that any of the fundamental rights have been violated by anybody, by any citizen, by the state government, or even by the central government, we can approach the courts. We can go to either the Supreme Court or we can go to the High Courts. About High Court, Supreme Court, we are going to discuss in our next video. So, under the system of upholding the law and enforcing fundamental rights, we can say that the citizens, they have the right to approach the court if they feel that their fundamental rights have been violated. So we can say here that the judiciary, it upholds the law as well as it also enforces or it protects the fundamental right of the citizens or the people. Now, after getting the different functions of the judiciary, we got three functions: dispute resolution, judicial review, as well as upholding the law and enforcing fundamental rights. Now the next point that we are going to study is what is an independent judiciary. Always you should know or you should remember that the judiciary or the system of courts, they are not under the control of anybody, not even the ruling government or opposition parties. The judiciary is always independent. And why it should be independent? See, the judiciary is totally free in its sphere, means the judiciary, it's totally free in its working or in its functions. It is not under the control or pressure of any other organs of the state. The judiciary, it is not either under the executive or even it is not under the pressure or control of the legislature. The legislature or the executive cannot interfere in the work of the judiciary. We already got that if the judiciary wants or if it feels that any law has been framed by the parliament which is against the interest of the constitution or against the fundamental rights of the people, it can interfere into the work of the legislature as well as the executive. But the legislature or the executive cannot interfere into the work of the judiciary. The courts are not under the government and do not act on their behalf. The courts, either the district courts or the high courts or the Supreme Court, they are not under any government and they do not act on their behalf. On their behalf means the court, they do not act as per the advice of the government. It is the independence of the judiciary that allows the courts to play a central role in ensuring that there is no misuse of power by the legislature or the executive. We can say it is only because of the presence of independent judiciary that the legislature or the executive, they cannot misuse their power, and even it is only because of the independent judiciary that all the people, all the citizens of the country, they enjoy the fundamental rights and they enjoy equality before the law. Well, now we are going to study about the last part of this video, structure of courts in India. I hope everybody knows that in India we have three levels of courts. See, it is given here. There are three different levels of courts in our country. In India we have three levels of courts. What are the three levels? One at the district level, one at the state level, another one is at the top level, that is at the center. The courts that most people interact with are called subordinate or district courts. India has been divided into many districts, and every district or each district is supposed to have one district court, and the district court is also known as subordinate courts. And generally the common people, for simple issues or for simple disputes, we move to the district court or the subordinate court. Each state is divided into districts. All the states, they are divided into different districts, and these districts are presided over by a district judge. You can say the head judge of the district court or the subordinate court is known as the district judge. Again, each state has a high court which is the highest court of the state. Every state, they are supposed to have one high court, and that is the highest court in the state. If any person is not satisfied with the decision given by the district judge or the district court, can move to the high courts. At the top is the Supreme Court that is located in New Delhi and is presided over by the Chief Justice of India. At the top level, there is the Supreme Court, and this Supreme Court, it is located in New Delhi and it is generally presided over by the Chief Justice of India. At present time, the Chief Justice of the Supreme Court is Sharad Arvind Bobde. Mr. Sharad Arvind Bobde is the present Chief Justice of India, and we can say that the decisions made by the Supreme Court are binding on all other courts in India. That means whatever decision is made by the Supreme Court, it must be followed by either the high courts or the district courts. And even the decision given by the district court can be changed by the high court, and the decision given by the high court can be changed by the Supreme Court. The decisions made by the Supreme Court are binding on all other courts in India. Any person who is not satisfied with the decisions given by the district court can approach the high court, and even if not satisfied, can move to the Supreme Court. This system is known as the appellate system, and through the system of appellate, we can say that first of all, if any problem is there, a person will be moving to the district court, and when the district court will give its judgment, if the person is not satisfied, he can move to the high court. Even then, if he is not satisfied, then he can move to the Supreme Court, and the decision given by the Supreme Court is final decision. It has to be followed by the high court as well as the district court. So that's the simple structure of the courts in our country, and that's about our first video or first part of this chapter. Go through the video, try to understand the points. If any doubt is there, please get it cleared. Thank you very much.